Impeached Judge John Hlophe has been nominated by the MK Party to serve on the Judicial Service Commission. Hlophe was impeached 4 months ago after being found guilty of gross misconduct. The former judge now serves as the MK Party's leader in Parliament. So can an impeached judge serve on the JSC? Let's bring in research consultant from Freedom Under Law, Chris Oxtoby, and Mavundlela Nkosana, who is the president of the Black Lawyers Association. Gentlemen, a very good morning to you. Thank you so much for making time for us this morning. I want to start off here. When we read the Constitution as it stands currently, Section 178, subsection 1I, is there anything as it stands legally that precludes not Chief Justice, but the former Judge President from becoming a member of the JSC, legally speaking? Chris, yes or no?
The very short answer is yes. But it's not directly contained in the provision that you've cited. One has to look at broader provisions of the Constitution overall, and I'm happy to elaborate on that. But if you want a short yes or no answer, then that's my position. Okay, we'll come back to that point that you want to raise. Mavundlela, from your end, is there anything that precludes John Hlophe from becoming a member of the JSC, legally speaking?
Good morning to your viewers and good morning to Chris and good morning, Eldren. Legally speaking, in terms of the provisions of the Constitution, no. If you reason it from the fact that the drafters of the Constitution could not have foreseen a situation that arises like this, where you're sitting with a former judge then wanting to participate in the politics. But what is worse, an impeached one, not somebody who decides post-retirement that I want to now participate in politics. Okay. Legally speaking, the answer is no.
The answer is no. Chris, you say that yes, if you take into consideration other provisions. What are those provisions that you'd be looking at?
So I think one has to look at Section 165, which requires all organs of state, including Parliament, to act in a way to protect the judiciary, to protect the independence of the judiciary. I think one has to look at the importance of the judiciary in our entire constitutional framework, the extent of the powers that the judiciary is given. One then has to look at the importance of the JSC in obviously appointing judges. In that context, I think to have an individual who has been found by, incidentally, these same organizations to have committed gross misconduct and to be unfit for the role, to have him then serve on the body that is involved in the selection of judges, I think is not only inappropriate, but I think it is legally challengeable. Of course, it is quite correct that there is not an express provision in terms in the Constitution that precludes this. I think, as was correctly stated, I don't think this is a scenario that was foreseen. But I do think that looking at the Constitution holistically, I think it does give us a basis to say that actually this would not be an appropriate appointment.
So Section 165 speaks about judicial authority. Chris, in what form would having a former judge president who has been impeached undermine judicial authority if that person serves on the JSC?
So I think it would severely impact public perceptions of the credibility of the appointment process. I think that's really the essence of it. I think it would create an impression that there is a blurring of law and politics, which, I mean, as we know, there is always going to be a certain overlap between the two. But we do try and keep distinctions in place between them. I think it would be harmful for public perceptions, for the credibility of the judicial appointments process and therefore the judiciary itself. And that potentially undermines the very independence of the judiciary itself if the judiciary is not perceived to be independent.
Yeah. Mavundlela, from your end, do you think that the judge president should be serving, a former judge president should be serving on the JSC, even though that very same body, its Judicial Conduct Committee, though, has found him guilty of a gross misconduct? And later on, the very House that he serves in right now also vote in favor for his impeachment.
Look, the expanding it to that extent actually even gives you more problems within the context of how we have structured the Constitution holistically. And if we look at how we have structured this Constitution, in the BLA, we start from a point that says, when we structured this Constitution in 1993-94 and its adoption in 1996, can we really say that we anticipated that we are going to have this kind of challenges? In all probability, no. And the very same persons going to serve in Parliament, in all probability, particularly as judges, no, because we know very well that the state is constituted by the three arms of the law. It's the judiciary, it's the legislature, and the executive. Now, when one comes from one set to go and serve in the other, and that person has been declared by that very body that they can't serve in the other body, then it gives you even more a challenge. But you see the danger, what Chris talks about as public perception. The danger is that in South Africa, you can't do anything unconstitutional on the assumption of the fact that you are worried about that body may be tainted. One, you are sitting with a body that is constituted in terms of the Constitution itself. And when that body is constituted, parliamentarians sit in that body and they take decisions on the basis of voting in that body. And the JSC does not necessarily appoint judges. They recommend judges for appointment by the president. So to the extent that they would that kind of difficulty will arise, these perceptions that Chris talks about, you can't erase them overnight. Judge Hlophe's issue as it unfolds in courts and also in the public space has thrown the spanner in the works in the manner in which we are interpreting our law versus our moral high ground as a society, to the extent that we are able to say, if you did this, why should you then go to the other side? Go to the very same processes where former persons who served sentences are now currently in Parliament. And then all of a sudden they are appointed to actually participate in certain committees of Parliament, and those committees may be dealing with the whole justice issue. What happens then if that person did not even believe that the judgment against them in court was whatever? So I'm just saying that the cross-cutting nature of our Constitution, applied vertically and horizontally, does not give us opportunity to say Judge Hlophe cannot participate in the JSC.
But isn't the difference here, Mavundlela, just quickly, the difference here that with the Judge President, the former Judge President John Hlophe, is that there was an investigation that was done, there was an inquiry, he was found guilty. He is, on the other end, arguing that the decision that was reached by the JSC was unlawful. He is challenging that particular decision. It is in the courts as it stands currently. And the difference between him and somebody like a Gayton McKenzie is that a prisoner would have gone through what is considered to be rehabilitation, and we don't know to what extent the former Judge President would have been rehabilitated when it comes to upholding his oath.
What I'm saying is that your direct translation of the Constitution does not give you that opportunity to go that route because of this realities of society. Yes, Judge Hlophe currently still sitting in courts, and that very question would arise: what happens if he succeeds in his argument in those courts? But we know that he has not succeeded in those courts. To the extent that Parliament had ended taking this decision, it means that process on its own, up to now, at least pending the decision by the Constitutional Court, which is currently asking as to whether those judges that are sitting there are conflicted or not, whether they can preside over his matter and so forth, are conflicted. If that matter ends with a conclusion that he is impeached, but he serves in Parliament, why do we think that if he can serve in Parliament, he can't serve in the JSC?
Okay.
Because Parliament is another arm of government.
And there's actually where the lawmakers sit, Chris, the point that Mavundlela is raising there. But just quickly in conclusion, you have written to the Speaker of Parliament on why Judge President or former Judge President John Hlophe should not be part of the designate going to the JSC. Has she responded as yet?
So receipt has been acknowledged of the letter. Obviously, the decision on these designations to the JSC was postponed. I'm not aware of any further response beyond that at this point.
Chris, unfortunately, we've run out of time. Thank you so much for making time for us. That is Chris Oxtoby, who is a research consultant from Freedom Under Law, as well as Mavundlela Nkosana, who is the president of the Black Lawyers Association.